Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
Shopify's point of sale system helps you sell at every stage of your business. Need a fast and secure way to take payments in person? We've got you covered. How about card readers you can rely on anywhere you sell?
Thanks. Have a good one.
Yep, that too. Want one place to manage all your online and in-person sales? That's kind of our thing. Wherever you sell, businesses that grow with Shopify. Sign up for your $1 a month trial at shopify.com/listen. Shopify.com/listen.
And Grinnell was so batshit crazy that McConnell tapped out and let Ratcliffe's nomination go through, and that's how he became Director of National Intelligence the first time.
Yeah, I mean, again, Mitch McConnell, don't confirm Rick Grinnell for anything. If you're like, well, he's moderate crazy, he's okay enough to go to Germany, but
I mean, he when he was there, I think he endorsed the Alternative for Deutschland when he was the representative of the U.S. government. He's not moderately crazy. Welcome to Law and Chaos, where the ghost of Jeffrey Epstein continues to haunt Donald Trump. Lower courts are still not letting the administration unperson children of immigrants, and Alina Habba is back in the U.S. Attorney's Office in New Jersey pretending to do real work. We've got a lot to cover, so let's get after it. Hey guys, I'm Liz Ty, and with me as always is Andrew Torres. Andrew, how are you?
I'm great, Liz. How are you? Did you have a nice weekend?
I did. It is very hot here.
Yes, it is.
Okay, let's start this off with a fun one. This morning, Donald Trump's lawyer, Alejandro Brito, filed a motion to compel in the defamation troll suit against Rupert Murdoch and the Wall Street Journal. That's the case over the story, saying Trump sent 50th birthday wishes to Jeffrey Epstein with a weird poem. The case was filed literally 10 days ago. Also this morning, the defendants asked for a 6-week extension of time to file an answer to the complaint, and the plaintiffs agreed. Now, Trump wants permission to depose Rupert Murdoch immediately because Murdoch is old. Andrew, do you want to Civ Pro this one up for us?
Yes, I do. Okay, so with respect to the complaint, ordinarily under Rule 12 of the Federal Rules of Civil Procedure, the defendant has 21 days to answer or otherwise respond after service, right? So that would be like August 12th. Trump has agreed to extend that response date to September 22nd, 6 weeks, which would seem to indicate that, they're not all that desperate to move this case along for obvious reasons. That, however, contradicts today's filing, which says, we got to move this thing along right now. So let's take a look. Yeah. First, it requests a de bene esse, or preservation deposition. And that, this might surprise you, Liz, is a real thing.
Yeah, it's Latin. I mean, I didn't think they were making it up.
Right. So in, for example, complex commercial litigation, which I've done a lot of, that the case is going to stretch on for years. And so in federal practice, for example, you often don't videotape depositions because deposition testimony is only admissible under certain conditions. Typically, the most common use of deposition testimony is to impeach trial testimony, right? So if I ask a witness at trial, are you sure you've never been to Hawaii? And they say, yes, I am absolutely certain. I've never been to Hawaii, but I've previously asked them in a deposition, hey, where have you gone on vacation? And they said Hawaii. Then I turn to the judge and I say, Your Honor, permission to introduce the witness's deposition testimony for purpose of impeachment. They're contradicting their earlier statement. That's where de bene esse comes in, because if you are deposing someone and you think you might not get the chance to pull that at trial because they might not be there, you would typically videotape their testimony. You would treat it like a cross-examination. You would treat it differently than a depo because it might be the only shot you get at this witness. If they are unavailable, you can then introduce that testimony in lieu of having to cross-examine them because, they're not there. And here, Trump is asking for it in the case of Rupert Murdoch, who is 94 and, the health of a 94-year-old evil billionaire tyrant, right? Whatever. I've also seen it with, pregnant witnesses, for example, corporate witnesses who are about to retire and flee the country. I shouldn't say flee, but, will not be available.
Yeah, no, it's funny that you mentioned that about commercial litigation because actually Brito is a commercial litigator. He's not a First Amendment litigator. So, all of that tracks.
Right. So Brito might be familiar with this process, but is definitely not a real part of the process to move for a preservation deposition of the first named defendant before he's been required to respond to your complaint.
Right. To be clear, the case is captioned Trump v. Murdoch. It's not captioned Trump v. Wall Street Journal or Trump v. Dow Jones, which is the holding company. It is captioned Trump v. Murdoch.
Right. And that's why that extension request was to answer or otherwise respond to the complaint, because Rupert Murdoch has the right to and almost certainly will move to dismiss this complaint in its entirety. And if he wins, he doesn't have to sit for anything, right? Like if you're not properly, served a lawsuit, right? You don't have to answer depositions. And in fact, the motion to take his deposition right now even tees up an argument that I think Murdoch is likely to use in one of his responses. And that is, it says, look, it's very, very important that we take his deposition because he doesn't live anywhere near this jurisdiction. It has nothing to do with Florida. And what the hell are you doing suing him personally in Florida, right? Like, he's not being asked to respond in Florida on behalf of News Corp, right? He's not there as a Fox witness, right? He is a named personal defendant. Murdoch will also argue that this garbage suit doesn't actually state a cause of action because it doesn't, it doesn't identify any actually defamatory statements or anything.
Yeah, just to jump in, the reason that they put, I also was surprised about this, about why are they saying in the complaint, well, he lives in New York. And that is because the distance of the deponent is one of the factors in the rule which allows for this da bene esse early deposition. But as you said, it points out the problem with personal jurisdiction in this case, although I don't know for sure. I don't know whether I think that they really are going to try and get this case booted on personal jurisdiction or moved to the state of New York. Because remember, this is the Judge Darren Gales, who sat over the case that Michael Cohen filed against Donald Trump. And Michael Cohen had a real good case to claim that the court had no jurisdiction of him. And he was like, no, I could move to New York, but I'm good right here.
Yeah, I think that's a really interesting quirk of civil procedure that you're pointing out here, right? Because Murdoch would move to dismiss for lack of personal jurisdiction against him in Florida. And I think you're right that Brito might respond, oh, Your Honor, don't dismiss the case. Just transfer this to federal court in New York and, roll the dice. But transferring it to the Southern District of New York is not likely to be a better draw for Trump either. So, I don't know. We will find out. Bottom line, I have never ever seen anyone move for a pre-answer deposition. This is going absolutely nowhere. Look, if there's some kind of imminent emergency, go to court, get a TRO, right? The courts have broad power to fashion injunctive relief. Federal courts have broad power under the All Writs Act to preserve their jurisdiction, right? There's a lot of stuff that they could do, and they haven't done it.
Yeah, the argument itself is kind of amazing. They're saying, well, we won't be able to depose this guy because he's so old and he might die. Meanwhile, A, Trump is no spring chicken, and B, Trump refuses to be deposed. In fact, the case that Michael Cohen filed was dismissed when Judge Gales told Trump, you have put this deposition off for 6 straight months, and I'm not going to let you do it anymore. So either go under oath or get out. And Trump chose door B. So it's very funny that he's like, no, you have to answer my questions right away when everybody knows he's never going to answer.
Yeah, I view this as a stunt. Donald Trump tries to make litigation as painful as possible for everyone, and Rupert Murdoch is one of the few people on the planet for whom he cannot oppress with costs. So I think he's trying to say, I'm going to suck up a lot of your time. I don't think it's going to work. But I do have to say, before we go, I've got to read paragraph 9 from this motion to you, because it says, Because defendants published the article after President Trump spoke directly with Murdoch and advised him that the letter referenced in the article was fake, Murdoch's direct involvement further underscores defendants' actual malice and intent behind the decision to publish the false, defamatory, disparaging, and inflammatory statements about President Trump identified in the complaint. And okay, Alejandro Brito, my dude, huddle up. Let's chat. You are well aware that actual malice in the context of public figure defamation does not mean personal animus or hatred. And I know you know this because you've lost on this issue representing Donald Trump in Florida.
Correct. And in front of a Trump appointee, in fact. That was the case that Trump filed against CNN, saying it was defamatory to use the word big lie about him because it implied that he was like a Hitler Nazi. And like, no, it did not. But one of the things that Trump tried to do in that case was say CNN did this out of political bias and because they hate me, and thus that's actual malice. And the court was like, no, that's not what actual malice means. Them not liking you, not evidence of actual malice. And as you said, like them not liking you and you saying it's not going to do it.
No.
Okay, while we are on the subject of Jeffrey Epstein, let's talk about Ghislaine Maxwell.
Oh, do we have to?
We do. Last week, President Trump's personal attorney, Todd Blanche, went to Florida for 2 days of discussion with convicted sex trafficker Ghislaine Maxwell. That's a sentence so mind-bogglingly inappropriate that it kind of refutes itself. Like Chris Christie said, there is no case to build, and against who she's in jail for 20 years and her co-conspirator is dead. So what exactly are they doing?
Yeah, wow, I never thought I'd be agreeing with Chris Christie, but here we are. This thing does indeed just reek to high heaven.
Yeah, let's count the ways this is batshit. First, Maxwell is someone the DOJ already indicted for perjury, although they did not take those charges to trial. They didn't see the point after she was indicted for sex trafficking. But the point is, she is not a trustworthy witness. She is someone who was convicted of sexual abuse of minors. Multiple women have testified that she participated in sexual assaults on them when they were teenagers, as well as grooming them to be assaulted by Jeffrey Epstein. Second, Todd Blanche is the Deputy Attorney General of the United States. He is not supposed to be participating in jailhouse interviews, particularly without FBI agents or line prosecutors there, because he doesn't have familiarity with the cases, which brings us to the third crazy glaring problem, which is that the DOJ just fired Maureen Comey, the chief prosecutor in the Epstein and Maxwell cases, maybe because her dad is James Comey, or maybe because she knows stuff that could hurt Trump. I do not know.
I don't either. I will say that the timing of that is really bizarre. Like, it took Trump 6 months to get around to firing her. And now when all of this is kicking up again, like she's suddenly out at DOJ, it seems weird.
Continuing with the list of ways that none of this is appropriate, Blanche and Bondi are both tweeting about this, and so is Maxwell's lawyer, David Oscar Marcus. He's talked extensively to the media, and he says that Blanche asked about 100 names, and Maxwell testified fulsomely and truthfully.
I'm going to assume that none of those 100 names were Donald John Trump.
Stipulated, yeah. Also, Trump refuses to rule out a pardon for Maxwell, the person who knows whether he contributed to this birthday album that he just sued over. He keeps saying that he just has the right to do it.
I know that's not the point here, but like it makes my ears bleed every time Trump says that, right? The pardon power is not some personal right that belongs to him. It is an official responsibility to the people of this country to rectify individual injustices that are caused by a broad, sweeping system, right? It's not a perk of being president that you get to distribute to your friends, right? Among the many, many things we have lost about the presidency and the rule of law is this commodification of the powers of the president, right? Like Trump talks about pardons like it's a coupon for free dry cleaning or something. It is so gross.
So gross, all of it. So Maxwell has this pending petition for certiorari before the Supreme Court. And actually, I read it. It's pretty smart. She submitted her reply today.
Yeah, look, no one thinks David Marcus is a bad lawyer, right? He's doing an amazing job for a terrible client. He has teed up a really interesting issue on appeal.
Yeah, you want to walk us through it?
Sure. So the issue here is that in 2007, Jeffrey Epstein got that preposterous plea deal in the Southern District of Florida where he could plead guilty to solicitation of prostitution instead of serially raping children. And that plea agreement extended to his co-conspirators. There is some suggestion that that provision was added to protect the girls who were then pressured to bring in their friends for abuse so that, the victims themselves would not be vulnerable to prosecution. Maxwell argued that she too was covered by the agreement, and thus it was illegal to prosecute her in 2019 in the Southern District of New York. The government counters that no individual U.S. attorney's office has the power to bind another U.S. attorney's office, right? That deal was Southern District of Florida. And, okay, take that question out of the context of this case for a moment. I tend to agree with Maxwell's argument, right? Like, you cannot have one arm of the U.S. government making promises and writing checks that the other arm refuses to honor. I mean, yes, U.S. attorneys are their own kind of fiefdoms, but they all still work for the Justice Department. Now,
yeah,
I should say here that the district court judge ruled that Maxwell had standing to sue, but was not a beneficiary of that plea deal. But as a procedural matter, she's not wrong that there's a circuit split on the issue of whether agreements with one U.S. attorney's office are binding on other U.S. attorneys. And the government acknowledges that. They just make a secondary argument in their response that says this case is a bad vehicle for resolving that split, which I bet it is.
Yeah, no shit. And all of this, of course, is going on with the backdrop of the Trump administration trying desperately to change the subject from Jeffrey Epstein after years of promising their supporters that they were just going to uncover the dirt. And now they're saying, like, nothing to see here. Move along. And meanwhile, Ghislaine Maxwell has been subpoenaed to testify before the House next month. Her lawyer, David Marcus, says she's considering it.
Okay, I want to lay down the marker now. There is no way on earth that woman is ever going to testify to Congress. None. That's ridiculous. Not even with a grant of immunity. She's a convicted sex trafficker that the government has already charged with perjury. Although, again, as you pointed out, they didn't take those charges to trial. There is no way she goes under oath. Be for real.
Yeah, I would agree with that. I mean, it's so weird that all of this stuff is kind of coming back around now for all of these people. And Trump kind of twisting himself and trying to get free of it is just making it so much worse.
Yeah, who would have ever thought that building a coalition on the path to power on the backs of conspiracy theory lunatics could backfire?
Yeah. Okay, it is Tuesday, so let's take a moment to thank our new supporters at patreon.com/lawandchaospod or lawandchaospod.com.
Yeah, on Patreon, a big thank you to Norman Schwab, Allison, Jess Faree, Andrew Van Stee, Ryan O'Leary, The HUD, and Ribbon on the Wind.
And over at Substack, thank you to Dan Kowalski, hey Dan, David Bruck, Terry Arnold, Calvin, Phyllis S., Kay Reeves, and Ryan.
Yeah, and if you'd like to join their ranks, get the shout out, get the bonus episodes, get the extended episodes, get every episode ad free. You know how to do that. Just head on over either to our Substack at lawandchaospod.com or on Patreon at patreon.com/lawandchaospod. Sign up, give us as little as $1 an episode, and we will show you our everlasting thanks. And as proof of that, our patrons are going to go right to the next segment, and everybody else can get a little brief ad break right here.
And we're back. Okay, so on June 27th, the Supreme Court's conservatives discovered that nationwide injunctions are actually unlegal. Who knew? They were totally illegal during the Biden administration, but now they're not.
It's the damnedest thing.
Ain't it? So the occasion of this discovery was a case called Casa v. Trump, challenging Trump's executive order declaring birthright citizenship null and void. There were a bunch of lower court orders saying, no, you can't magic away the 14th Amendment in an executive order, you fascist idiot, or words to that effect. And so after the Casa ruling, lower courts had to figure out what the hell to do in the birthright citizenship cases because they'd issued all of these nationwide injunctions and the Supreme Court said, no, we don't like nationwide injunctions now. 3 courts so far have continued to issue nationwide relief. In State of Washington v. Trump, the Ninth Circuit agreed with the trial judge that the coalition of blue state plaintiffs needed a nationwide injunction because parents and children move around the country, and it's impossible to know how to treat people who are citizens in one state and non-citizens in the state next door. That's the same reasoning as the case we're going to talk about today. Also, in a case called Barbara v. Trump, trial judge Norman LaPlante of the District Court of New Hampshire certified a nationwide class of babies born to non-citizen parents and protected the right of these children to get birth certificates. And then on Friday of last week, in the District Court of Massachusetts, Judge Leo Sorokin issued a, quote, order on scope of preliminary injunction in which he affirmed that the relief he had previously granted was still nationwide in scope.
Yeah, so a lot of procedural background here, which begins with the fact that the government had already appealed Judge Sorokin's original preliminary injunction, and that was pending in the First Circuit before the Supreme Court's opinion in Casa v. Trump came down. So when Casa came down, the First Circuit remanded the case back to Judge Sorokin and said, look, we just have new guidance from the Supreme Court. So we're remanding to you for the limited purpose of considering the bearing, if any, of the Supreme Court's guidance in Casa and to address any argument that the parties may advance with respect to what grounds may now be asserted regarding the injunction's scope. And Judge Sorokin considered it, and then he said, yeah, this executive order is still flagrantly illegal. And I guess we should. Yeah, right. So I think we should sort of clarify the Supreme Court's holding in Casa. So, let's be precise, right? Because commentators, including us, have called it a ban on nationwide or universal injunctions. And this does not quite technically correct it. So what the Supreme Court made up in Casa is structured around a real legal principle, right? That courts should only award relief to the parties that are before it. And again, it's true, but it has never meant what Justice Barrett construed it to mean in Casa. So pre-Casa, if you challenged a statute or practice as unconstitutional, let's say the Biden administration's policy on student loan forgiveness, right? So if a court were to say that loan forgiveness is unconstitutional, as a court in Texas did, then the relief that court awarded is prohibiting the administration from carrying out that unconstitutional policy. And that relief applies nationwide. So even though it affects everyone else, right, it affects a whole bunch of people who have student loans, the relief was only to the plaintiffs, right? If the Biden administration had carried out that order anyway, then other people could not have moved to enforce the judgment or sought sanctions. Only the plaintiff in that case could have done that, right? And so the reason that courts have awarded relief that affects non-parties, again, for more than a century, nationwide injunctions, has to do with the rule of law, right? Because once a court of competent jurisdiction has said that a law or policy is unconstitutional, one of the fundamental principles of the rule of law is that we don't let the government just forum shop around to try and find a more favorable judge to say the opposite, right? Like, you cannot relitigate that question once it has been decided. You can appeal. You get one appeal as of right to the Court of Appeals. Then if you lose, you can try and convince the Supreme Court to grant cert, but that's it. So without that principle, the idea that you can extend relief that affects others beyond the plaintiff themselves, you would never know what the law is, right? Every time the administration lost in court, they could just try and find another judge to rule the other way. So nationwide injunctions award relief to the party that's before it, but they have secondary benefits that apply to everyone else.
Right. And look, think about this. Illegal, unconstitutional shit is illegal no matter whether you're standing in Oklahoma or Ohio. But the 6 conservative justices are very hot to let Trump do illegal shit. So that's how we got here.
Yeah. So in Casa, Justice Barrett and the court's conservatives construed that concept of relief to the plaintiffs that are before the court very narrowly in a way that, again, is at odds with a century of jurisprudence, right? And so now a court cannot award, this is the language from the opinion, more relief than is necessary to provide the plaintiff and only the plaintiff complete relief on their claims. That was all that nonsense in Justice Barrett's opinion, saying that the individual plaintiffs in that case ensured that their own babies got citizenship. So, that was enough. So what all of that means is that Casa isn't exactly an outright ban on nationwide injunctions. It was, strictly speaking, a ban on injunctions that issue nationwide relief when the plaintiffs aren't suffering a nationwide injury, right? When you can make them whole with something less than that. But if you are suffering an injury that requires a nationwide injunction, CASA's no bar. You can still get it.
Right. And that left the states as the best plaintiffs since they represent the greatest number of people. And they have standing to argue that a patchwork quilt of citizenship rights is wholly untenable, particularly in light of the Trump administration's DOH campaign to create one pool of federal information containing every bit of data on every individual, which they will then use to ferret out non-citizens, the better to snatch them off the street and summarily deport them, of course, but also as a reason to deny states federal funding. So what if, say, a baby is born in Texas where he is treated as a non-citizen? Then his parents move to Maryland and apply for Medicaid or Head Start or whatever social program Trump's ghouls are trying to rip away from poor kids. Is the state of Maryland supposed to deny that child benefits because she was born in Texas and isn't a citizen? Is the federal government going to ding Maryland for fraud if the state enrolls her in Head Start? Like, what is going to happen here?
Yeah, and without a nationwide injunction, we don't know. And so even under the new rule in CASA, the only way to give the plaintiff states complete relief on their claims, right, to say what the law is to enter a nationwide injunction.
Right. And that brings us back to Judge Sorokin, who paints this sort of goofus and gallant picture of how the parties litigated this case on remand after CASA. Like, on the one hand, the plaintiff states submitted extensive documentation of how allowing red states to unperson these babies would make it administratively unworkable for blue states in things like Head Start. And in reply, the DOJ submitted two giant middle fingers, more or less. Judge Sorokin says the plaintiffs supported their legal arguments with dozens of sworn declarations from subject matter experts and public officials describing harms the executive order will visit upon the plaintiffs. The defendants, on the other hand, submitted no evidence to support the positions advanced in their own memoranda. They did not dispute, generally or specifically, the substance of the plaintiffs' factual submissions, nor did they offer their own declarations in rebuttal.
Okay, so a bunch of super interesting things going on in this opinion. But let's talk about the holding first before I get overly distracted with procedure. Judge Sorokin said the plaintiff states have met their burden for a nationwide injunction because it is untenable for states to have to bear the burden of two differing classes of citizens in this country when eligibility for federal programs for which they are reimbursed is governed by citizenship status. He says significant confusion or changes impacting the eligibility or administration of such programs will require states to examine and revise existing systems. Shifting citizenship status, depending upon the location of the child or the purpose animating a citizenship determination, is a state of affairs without precedent in this country for at least 150 years. Federal law and state systems are not designed to respond easily to such a regime. The fear and confusion arising from implementation of the executive order would thwart states' ability to discharge those obligations under federal law and likely would also chill enrollment in critical programs impacting children's health and well-being, leading to increased and unpredictable cost to the plaintiffs. Principles of equity do not favor requiring the plaintiffs to shoulder these burdens while this lawsuit proceeds.
Yeah, I see that as a really unsubtle reference to the Fugitive Slave Act. Because we have had people in this country who had rights in one state and did not have rights in another. And it was untenable. And we had a civil war. And we don't do that shit anymore, except the Trump administration wants to do it again.
Yeah.
We just can't have people who are citizens in one place and non-citizens in another. That's not a thing. So that's issue one. Issue two is whether there was any narrower form of relief besides a nationwide injunction, which would do it, right? Because the Supreme Court has said it can't be a nationwide injunction unless that's the narrowest form of relief that will provide complete relief to the parties. And Judge Sorokin said basically, well, states proved their point and the government didn't show up, so too bad, so sad. He says sometimes the adversary process reveals a narrower form of injunction sufficient to avoid, during the pendency of the lawsuit, the injuries supporting the claims of a plaintiff. Not here. This conclusion arises at least in part from the defendant's refusal to engage with the parameters or feasibility of even one narrower alternative.
Yeah. Gallant files affidavits and cites cases in his briefs. Goofus shouts, "You're not the boss of me," and, breaks wind in court.
More or less. Yeah. So basically, the Justice Department suggested that the judge just require the government to treat children of non-citizens as if they were citizens for the purposes of eligibility for government programs, but only when those children were physically present in blue states. And Judge Sorokin said, no, that's still going to increase the administrative burden on blue states by making them wade through a morass of paperwork trying to figure out who is a citizen under this preposterous crazy quilt scheme. So the nationwide injunction is the narrowest form of relief that will, provide a complete remedy to the plaintiffs. I should say we've talked a lot about the old bulls like Judge Royce Lamberth or Judge Harvey Wilkinson on the Fourth Circuit who are out of F's to give. And Judge Sorokin is not one of those, right? He's a 64-year-old Obama appointee, but he still conveys undisguised shock and disgust that the Supreme Court has cut off a remedy for nationwide constitutional violations under this kind of ridiculous thing about nationwide injunctions are no good and we never had them before when clearly we did.
Yeah.
I really don't think you can get around how appalled he is that he, the court's job is to protect people in this country, citizen and otherwise, from constitutional violations. And here the Supreme Court saying, no, you can only protect some people, which is nuts. Yeah. Anyway, let's talk about the third issue, which is why is the government litigating in this fashion? I have some ideas, but Andrew, what do you think is going on here?
Okay. I think I've said on the show, John Sauer is a smart lawyer. I'm
the Solicitor General.
Evil. Right. The Solicitor General of the United States is probably the smartest of Trump's personal lawyers, right?
Oh, yeah.
I've listened to many of his oral arguments, including on cases that don't have a political component, right? He is competent. He is smart. He knows what he's doing. And I think he has convinced his client and subordinates that the Supreme Court is not going to reverse Wong Kim Ark. The Supreme Court is, if asked, if teed up directly in front of it, does citizenship convey with being born in this country, is going to say, yes, it does. And so I think what they are looking for are ways to slow down the process, throw enough sand in the gears, do whatever they can to undertake a policy that everybody knows is unconstitutional without having to tee it up for the court. What do you think, Liz?
I do. And I also think what we're talking about here is a sort of defiance of lower courts that has been engendered by the Supreme Court's behavior in this and all of these other cases, right? That the Supreme Court has made its own contempt or disregard for trial court judges and their role in this process so clear, right? They've allowed the government to get away with contemptuous behavior and disrespect. And I mean, Judge Kavanaugh acknowledged it in one of the immigration cases, the Alien Enemies Act deportation cases, where he said basically, we are the ones who are going to have to decide this, so don't even bother sending it back to the trial courts, which was, I guess, telling the truth, and I admire that in some fashion. But it was a not even tacit, an explicit acknowledgement of the fact that the trial courts are not going to play a role in deciding any of these real cases, that it doesn't matter what the trial courts do. And so my read on this is that the Trump administration has received that message loud and clear and is like, yeah, whatever, get to the important part because nothing you have to say here makes a damn bit of difference.
Yeah, I don't disagree with that at all.
All right. We're going to take another ad break unless you're a subscriber, in which case no ad breaks for you. See you guys in a minute.
And we're back. Last Thursday, we told you in a written post at lawandchaospod.com that Alina Habba was probably headed for the exit in New Jersey. And that's because Habba was appointed by Attorney General Pam Bondi as the interim U.S. Attorney for New Jersey more than 4 months ago. She was appointed pursuant to 28 U.S.C. Section 546, and under that law, her term expires automatically after 120 days. She should be gone.
She should never have been there in the first place. Sorry.
Yes. And then on Friday, the Trump administration said, no, not so fast. And they tried an end run around Section 546 with another law called the Federal Vacancies Reform Act. The administration is wrong. They are breaking the law. This is headed for the courts. And to understand why, let's talk about both of those laws.
Okay. Both statutes are subject to the general rule set out in the Constitution called the Appointments Clause. That's Article 2, Section 2, Clause 2. And it says in relevant part that the president shall nominate and by and with the advice and consent of the Senate shall appoint all other officers of the United States whose appointments are not herein otherwise provided for and which shall be established by law. So that means that anyone who is a principal officer, meaning people with frontline decision-making capacity in the executive branch, has to be nominated by the president and confirmed by the Senate. That's the bit about advice and consent. This is an important cornerstone of separation of powers, right? The president isn't allowed to pick just any unqualified dingbat to serve in a critical capacity. The Senate is supposed to reject nominees who lack the experience or judgment or temperament or ethical and legal qualifications to serve.
Yeah, bang up job the Senate's doing.
God, I know where you're going. But hang on a sec.
Yeah, okay. So back to the Appointments Clause. The Constitution envisions, as part of that separation of powers, that the Senate vets important nominees and rejects the ones who aren't fit to serve. I know. But sometimes the Senate is in recess, right? Like the Senate is taking off a month in August, starting next week, for example, right? There are 6 more recesses after that scheduled for the fall and winter. And look, even when the Senate's in session, things can move real slowly.
Yeah, no, I worry that people are going to think that this is going somewhere where it's not. About recess appointments, because we've talked about that on the show before, that that Trump was going to try and force everybody to go into recess and kind of jam people in there as a recess appointment. And no, that's what happens is that somebody comes and gavels in at the Senate for like 30 seconds and then gavels in and immediately gavels out in a pro forma session. Actually, Joe Biden, because he lived in Delaware, which was pretty close to D.C., used to have to do those a lot, as did the senators from Maryland and Virginia. They used, but anyway, they come in. So there's not going to be recess appointments. I know that people think, oh, here's that trickle coming. That's not coming right now. We've got different problems today.
Right. But no, it is worth pointing out those pro forma sessions are designed to prevent Trump from bypassing Senate approval. Okay. Back to kind of as a relic from normal times, right? Congress, from the very beginning of the Republic, passed a bunch of laws that let the president make interim appointments, recognizing that, sometimes the Senate just isn't going to be there. And look, like that is 100% necessary to make sure that the government functions, right? Like if let's say the Secretary of State dies, like you can't go a month plus without having a Secretary of State. I mean, okay. I go the rest of my life without Marco Rubio, but you get the principle, right? Like, and again, those laws go back to the first Vacancies Act, which was passed in 1792.
Yeah, you know what? I think that is kind of a relic of a bygone era of smaller government too, right? Like not having a confirmed Secretary of Education or Agriculture is going to like cause those two agencies to shut down. Even not having a Secretary of State isn't going to cause it to shut down, right? Because we now have a much bigger federal bureaucracy.
Yeah, we have a deep state. Yeah.
Well, we have right. Thank God for the deep state. Anyway, but yes, that is the backdrop for the two laws that come into play with respect to Alina Habba. So the first is it's specific to the job of U.S. Attorney. It is 28 U.S.C. Section 546, which you just referred to. And it says that the Attorney General can appoint any attorney for the district in which the office of the U.S. Attorney is vacant. So here, the position is vacant because the prior U.S. Attorney for New Jersey, Phil Selinger, resigned, as routinely happens when the White House shifts parties. These positions are understood, at least in the modern era, to be political positions. Okay, so under Section 546, the interim U.S. Attorney serves for 120 days or until a permanent nominee is confirmed by the Senate, whichever is shorter. And there's no prohibition on appointing a person on an interim basis while their nomination is pending, which is what Trump did with Habba, eventually. But he didn't formally send Habba's nomination to the Senate until last month, which suggests to me that he wasn't serious about putting her in there permanently. I mean, nominations... Well, we'll talk about it in a sec. Nominations for other positions besides U.S. Attorney are taking like 3 months. So if he wanted to get it done realistically, he'd have had to start earlier. So anyway, last week, Habba's 120-day interim appointment expired.
Right. And the district court in New Jersey could have voted to keep her on the job under Section 546, subsection D, which allows the judges in that district to appoint someone to the job when an interim appointee's term expires and no permanent nominee has yet been approved by the Senate, which is exactly what we have here. And that appointment, by the way, has no expiration date. So if Alina Habba had been a minimally competent prosecutor, the judges of the district court probably would have tapped her. And, she could have then served out the rest of Trump's term without Senate confirmation.
And if your Bubby had wheels, she'd be a wagon.
A Vogon? Anyway, so instead, because Alina Habba is spectacularly incompetent, ethically challenged, right, they appointed her handpicked chief deputy, right, a career prosecutor named Desiree Grace, to assume that position when Habba's term expired, at which point the Trump administration all of a sudden decided they cared very deeply about keeping Habba on the job.
Right. So Thursday, Attorney General Bondi says she has now fired Grace, which she can't do, but Trump probably can. So let's just assume it happened.
Yeah, I don't know that I agree with that reasoning that Trump can fire under existing case law, but I'm going to preempt my own rabbit trail in advance. I'm not sure it matters because this Supreme Court has signaled that they think Trump can fire anyone he wants within the executive branch and will happily change the law even if it says otherwise.
Yeah. Okay, so Friday, Trump tries to maneuver Habba back into office under a different law. So he withdraws Habba's nomination to the Senate for this permanent gig. And then he names her as the first assistant U.S. attorney for New Jersey, basically her own deputy. And then he formally fires Grace. And after all that, Trump argues Habba gets to automatically succeed herself under the Federal Vacancies Reform Act, or succeed Grace if indeed Grace held the position for any amount of time. Habba certainly thinks she's back. She tweets, "Donald J. Trump is the 47th president. Pam Bondi is the attorney general. And I am now the acting U.S. attorney for the District of New Jersey. I don't cower to pressure. I don't answer to politics. This is a fight for justice. And I'm all in."
Alina Habba is not back. She's not all in. I mean, at least not legally, right? Habba. Yeah, well, back up the G-wagon.
She ain't all there. Yeah.
So she was named interim U.S. attorney, as we've said, under 28 U.S.C. Section 546. That's the law, as you said, Liz, that applies only to interim appointments of U.S. attorneys and no one else. Section 546 sits on top of a larger statute, the Federal Vacancies Reform Act of 1998. And that one applies to any officer of an executive agency whose appointment to office is required to be made by the president with the advice and consent of the Senate. So yeah, a principal officer, that's 5 U.S.C. Section 3345. And under that statute, a vacancy occurs when a principal officer dies, resigns, or is otherwise unable to perform the functions and duties of the office.
Right. So before we get to how a vacancy is filled, the very first question is whether the FVRA lets the president fill a vacancy, which he himself created by firing the previous occupant. Does that mean the person is unable to perform the functions and duties of the office? Because got a pink slip from the president.
Grace was perfectly able to perform the functions and duties of that office.
Right. Because that's arguably not what the law says. And the history of the FVRA is crystal clear on this point. It was passed by Newt Gingrich during the Contract with America Congress back in 1998. And this law was explicitly and directly intended to rein in Bill Clinton's powers to do just what Trump is doing. And we know that because of an opinion written by Chief Justice John Roberts way back in 2017.
And we're going to get into a deep dive on that opinion on how, everything is totally different in the 7.5 years since then in the subscriber bonus, which is available for all of our subscribers over patreon.com/lawncastpod. For everybody else, we're going to take a quick ad break and we will see you on the other side with the rest of this story. But I think you want to stick around for this one. It's a good one.
And we're back. All right. So assuming that the Federal Vacancies Reform Act lets the president fill vacancies he created by firing the occupant, which dubious, but with the Supreme Court, who knows? Here's how the rubber's going to meet the road. The president can interfere with the normal succession in two ways. The first is that the president and only the president may direct a person who serves in an office for which appointment is required to be made by the president by and with the advice and consent of the Senate to perform the functions and duties of the vacant office temporarily in an acting capacity.
Yeah, and that means that if somebody has been already confirmed by the Senate to some other position, then the president can take that person out of that role and have them act in a temporary capacity to fill a different vacancy throughout the executive branch. And again, you can understand why, right? If the Senate has already said, okay, this person is qualified, not a crony pick for some other high-level executive job. That's reasonably consistent with the separation of powers. Like if you're in the Senate and you don't want someone to be shifted over to another high-level job, don't vote to confirm them to any high-level job, right? This is not a perfect system, right? Like I could imagine saying, for example, okay, this lawyer is qualified to be an acting U.S. attorney, but I sure as hell wouldn't want them to be, I don't know, acting Secretary of Health and Human Services. But it's fine. It's fine.
Counterpoint. That is how Trump forced the Senate to confirm John Ratcliffe as DNI in 2020. Because first the Senate, which was controlled by Republicans, balked and said no way, because Ratcliffe, who was actually then a congressman from Texas, had lied so egregiously on his resume about his prosecutorial experience. But then Trump put Rick Grinnell on the job because Grinnell had previously been confirmed as ambassador to Germany, and so he could be put anywhere, basically. And Grinnell was so batshit crazy that McConnell tapped out and let Ratcliffe's nomination go through, and that's how he became director of national intelligence the first time.
Yeah, I mean, again, Mitch McConnell, don't confirm Rick Grinnell for anything. If you're like, well, he's moderate crazy, he's okay enough to go to Germany, but
I mean, he when he was there, I think he endorsed the alternative for Deutschland when he was the representative of the U.S. government. He's not moderately crazy.
No. So look, the point I think, lest I have stepped on a little bit, is that Trump has a long history of testing the limits of all of these laws, right? None of which were created in anticipation of having, a narcissistic nihilist with his hand on the nuclear button.
Yeah. So the other alternative in the FVRA is that the president and only the president can elevate a non-Senate confirmed person to fill a vacancy if they've been employed in the agency for at least 90 days prior to the vacancy and they're at least a GS-15. So the idea is that the president can elevate a competent subordinate to fill the top job while this process is going through. Neither one of those rules applies to Alina Habba, though.
No, they do not.
So Trump's argument is that the normal succession rule applies, that the one that says the first assistant to the office shall perform the functions and duties of the office temporarily in an acting capacity. So Trump's argument is that by making Alina Habba the first assistant to herself and then firing Grace, Habba automatically was entitled to perform the functions and duties of the job she just timed out of.
Yeah, and in addition to that sounding as crazy as it is, as it turns out, Newt Gingrich anticipated that some, wily Democratic president, no doubt, might try this kind of rigmarole. So Section B of that same provision, 3345 of the Federal Vacancies Reform Act, says that a person may not serve as an acting officer for an office under this section if they've been a first assistant for less than 90 days and here the words are important, the president submits a nomination of such person to the Senate for appointment to such office. So the argument here is that Trump is saying that by pulling Habba's nomination and then, making her own deputy, that gets around that exclusion. But that's not what the law says. The law says once the president submits your nomination to the office, you cannot be named as an interim appointee under the Federal Vacancies Reform Act at all. And again, we know why they did that. They did that because that's what Bill Clinton did with Bill Land-Lee that made the Republicans so mad back in 1998, which again, you were in the Patreon bonus. We explained that to you. Once you have been submitted at all, doesn't matter if the president later pulls your nomination, you lose your eligibility to be named as an interim appointee under the FVRA. You could still be named under 546, but that window has closed.
Yeah. Well, I guess the Supreme Court will just yank her nomination then.
Good.
No.
All right.
All right.
Nothing,
we got
nothing
more on
else
this
to
one.
see here.
Hang on a sec. We're going to take one more brief ad break. We will be right back.
And we're back. Okay. So the fact that Trump pulled Habba's nomination does not make her eligible under the FVRA. But here's the thing. We know that this is going to be litigated because of the well-established remedies when an appointment under the FVRA is improper. And that is that everything that appointee does is considered a void ab initio from the beginning. None of it counts. It is all unwound.
Yeah, and we know that because Trump ran this playbook before. In 2019, he named Ken Cuccinelli, who is the former, I think, Attorney General of Virginia, and a complete loon. He once tried to ban sex toys. That's not important to this discourse. But anyway, in 2019, Ken Cuccinelli was named to a position which Trump just made up. He called it the Principal Deputy Director of the United States Citizenship and Immigration Services. And then Trump fired the actual Senate-confirmed director and said, hey, under the FVRA, ipso facto, Cuccinelli is now the acting director, which, of course, got litigated in D.C. And Judge Randolph Mall said, no, Cucci's appointment was not legal because Principal Deputy Director is just made up and did not qualify as the first assistant under the FVRA. So Cuccinelli was ineligible to, ascend to that top job because he never served in a subordinate role at USCIS, which meant that every single thing Cuccinelli did while acting as head of USCIS was void ab initio. Cuccinelli was acting head of a department. Actually, two departments. He was also acting Deputy Secretary for Homeland Security. So he made policies that could be, and in fact were, unwound.
Right. So now import that over, because if a U.S. attorney has no authority to hold the office and everything they've done is void from the very beginning, that means she's got no authority to indict, to try, to convict, or to reach a plea bargain with any criminal defendant.
And so anyone who falls into that category is immediately incentivized to litigate Habba's appointment. And we know that because we've been here before, although not in New Jersey. It was in Puerto Rico with an appointee named Geronimo Gil, who held the job for 6 years on an interim basis. I think he was appointed by the court under Section 546,
yes,
if I recollect. So neither George W. Bush nor Barack Obama named a replacement, and so Gil just stayed there because for across two administrations. And because the interim appointment stretched out across a couple of administrations, a whole bunch of people challenged Gil because they were convicted, and they said, well, it doesn't count because Gil wasn't officially appointed. He was here too long.
Right. It never hurts to try. Now, we should say all of those defendants, except one, lost at the trial court level. There were like 7 or 8. But the one who did succeed at the trial court level did, in fact, get an order vacating his criminal conviction, right? Now, that case was overturned by the First Circuit, right? The First Circuit said that Gil's appointment could run forever if need be, right? But these are the stakes, right? I think if Habba's appointment is invalid, then it's possible that every criminal defendant her office has or will come into contact with is going to walk.
I'm not in agreement with you there, but okay. But in fact, defendants have already started to challenge. Politico flagged a case that was filed by a man named Julian Gerard Jr. His lawyer, Thomas Morigliano, moved to dismiss the case on the theory that Habba was, as you said, illegally appointed in violation of the FVRA, and thus anything she touches is ultra virus. But look, I suspect this case isn't going anywhere because the guy's trial is next week. And he was indicted in 2024 by Philip Selinger, as we said, the U.S. Attorney for New Jersey, when we had a president who actually cared about Senate confirmation and the law. But more relevantly, I suspect that the Third Circuit and the Supreme Court would say that the line prosecutors don't derive their authority from the U.S. attorney, whether it's Grace or Habba or whoever. They work for the Attorney General of the United States. They work, administration in, administration out. And so the legality of Habba's appointment won't affect any of the cases that her office prosecutes. But that said, like, everyone is going to try.
Yeah.
That office is going to indict someone tomorrow, and that defendant is going to say this indictment doesn't count. And the Justice Department is going to have to spend a lot of time dealing with that headache. In this case of Julian Girard, they actually transferred the case to another judge to determine this motion, to a judge in Pennsylvania, because determining, to evaluate the U.S. attorney in that district on a case that involved this 546 appointment by the judges in that district, they figured it was a conflict, and so they transferred it out. It's just another headache. It's just another piece of chaos, which the Trump administration absolutely doesn't need at this point. I mean, they've got a lot of chaos going on, and yet they steered directly into the iceberg. Look, maybe you can say that they kind of played chicken with the judges on the district court, or that they anticipated that these judges would in fact confirm Habba. I don't know that that's true, and I don't know why they would think that. But also the fact that it took them 3 months to get around to nominating Habba makes me think they weren't that serious about putting her in for a permanent position. And then they just got mad when the judges told them no. I mean, I've read that Habba wasn't showing up at the office because she knew she was done. But, I mean, counterpoint to my own theory here, this isn't the only district where this crazy shit is happening. The Wall Street Journal says today that there are 30 pending nominations for the 93 U.S. attorney positions. So less than a third of them, the Trump administration has bothered to nominate somebody for these jobs. And there have been zero confirmation. But the reason for that is that Senate Minority Leader Chuck Schumer put a hold on U.S. attorney nominations to protest Trump's used Qatari jet boondoggle, which I think you guys remember that. Like that's the plane that he took from the Qataris as a gift. And incidentally, I read that they're hiding the $1 billion rehab bill for this plane, which is going to be turned over to Trump anyway. They're hiding the funds for the rehab in a classified nuclear weapons funding package. Which doesn't make it seem less hinky. Anyway, but the point is, on this topic, with the issue of these confirmation of the U.S. attorneys, you have a politically constructed time bomb because Trump has put all of these political hacks on the job and either didn't nominate anyone to replace them or cannot get the replacement nominee confirmed, right? I mean, you've said you thought that Habba might not get confirmed.
Yeah, I think for the reason that you've described, that I'm holding out a sliver of hope that maybe she falls into the Ed Martin level of unconfirmable. But so far, that appears to be a universe, an island of one. But Alina Habba could join him on that island any day now.
True. Okay, but irrespective of whether she can get confirmed, they don't have nominees in the pipeline, and the nominees that are in the pipeline are not getting confirmed. So all of these interim appointees that are going to time out after 120 days, you're going to see this problem replicated in every district. Or let's say, I think it's going to be more so in blue districts than red ones because of the judicial makeup, of the judicial bench, and the hangover from the days when we still had a blue slip system.
You want to walk us through that?
Yeah, so look, in the olden days, home state senators could veto a judicial nominee by refusing to return what was called a blue slip. So if they didn't sign the permission slip, the nominee didn't go. So Bill Clinton wanted to nominate a judge in, say, like Alabama or Mississippi. He had to get buy-in from both of the home state senators. And so it was a moderating force on the judiciary writ large because in states where the president and the Senate were from different parties, they had to agree. Yeah. But then we sort of got rid of that in the past 20 years because McConnell refused to confirm any Obama nominees. That's honestly the reason. But all right, let's play this out because maybe it's not clear. Say that Trump wants to shoehorn some crazed hack into the U.S. Attorney's Office in the Northern District of Texas. Like, I assume that the judges will save him the trouble of getting that nominee confirmed and just appoint them under Section 546. They refused to do that for Alina Habba because she's a hack and because the U.S. District Court in New Jersey is not the U.S. District the judges are going to be a different makeup in New Jersey from in the Northern District of Texas. And
New Jersey is 15-2 Democratic appointees.
Right. I mean, the Northern District of Illinois, like more liberal jurisdictions that have judges who were appointed under the blue slip system, and even not more liberal jurisdictions are going to have more liberal judges who are going to refuse to go along with the Trump administration's plan to install these hacks using Section 546 to evade Senate confirmation, right? And we've seen this play out in the Northern District of New York with this guy, John Sarcone, we talked about on the show last week, right? The Trump administration put that guy in, did not bother to nominate him for a full term. And then when his term expired and the judges refused to install him under Section 546, they did the same thing they did with Habba. They put him in as his own assistant, and then they elevated him to the vacant spot. And because he hadn't been nominated to a full term like Habba, they could do it more or less cleanly.
Yeah, that ineligibility provision in subsection B didn't kick in for Sarcone.
Exactly. Yeah. And I think we're going to see them do this, for instance, in the Central District of California, where they had this goon, Bill Asaley, who's serving as a U.S. attorney on an interim basis. He has not been nominated like Sarcone. I mean, he's like ridiculous. He's the one who indicted the guy handing out gas masks to protesters for conspiracy. They haven't nominated him, which makes me think that they've either abandoned the process or have chosen people they know can't get confirmed. And it's sort of a dare with the judges in the district to say, you install our guy or we're going to pick a fight with you and it's going to get ugly. And I mean, I could see them doing a bunch of crazy shit to keep Asaley in office when his term expires next month. In fact, Asaley, I think he was on Glenn Beck and said like, well, we have some tricks up our sleeves to do that. Like, he's tacitly acknowledged that's what's going to happen.
Yeah, we will see. You have laid down your marker, and I never hope that you're wrong, but I do hope you're wrong on this one. We will find out. Okay, one last thing before we go. This feels like an echo from 100 years ago, and it is that today, as you're listening to the show, is the beginning of Hunter Biden's defamation suit against Patrick Byrne. Patrick Byrne, the billionaire weirdo who founded Overstock.com, was a major funder of the Stop the Steal movement. We've been following this case intermittently. We've been following Dominion's lawsuit against him with considerable more enthusiasm. But this is the one where Byrne kept insisting that he had to be deposed remotely via Zoom because he'd fled to, I think, Dubai because, the Venezuelan government had put a $20 million bounty on his head or something. It was amazing.
He is crazy as it. I cannot imagine. Like, jury selection is ongoing as you're listening to this probably. I cannot imagine being the jury on this. It's yeah.
That's going to be some good voir dire.
Yeah, so I can't imagine what it's like to be on that jury. I can't imagine what it's like to try a case with a party who is so wackadoodle. Sadly, though, Patrick Byrne is not represented in this endeavor by Stephanie Lambert Gentilla, the one who got thrown off of the Dominion case for being too crazy and leaking discovery materials.
The most qualified lawyer in the country, nay, the world.
Yeah. It would have been in an alternate universe. This is what we're talking about. This is the main topic of our show because Trump didn't win and we get to go on and talk about Rudy Giuliani and Patrick Byrne and be happy.
I would give anything to live in that universe.
I want to go there. All right, you guys, that is going to do it for us today. We will be back on Thursday with written content and on Friday with another podcast. Thank you for hanging out with us. And if you enjoyed the show, please like us and leave us a 5-star review on your podcast platform of choice. Thanks, guys.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.